All right, I'm going to begin. What I was doing is I was waiting for a minute because there's a few people here that I want to introduce to you. Is he? There he is. All right. This gentleman up here in the green t-shirt who's running up the stairs is a former POW. We actually have his testimony. I consider Mel's, as well as many of the POWs who survived the tortures committed by the Azerbaijani forces, our heroes. And what I'd like to do is actually ask him to stand up, because I believe we need to recognize him. Mel's, thank you. He's not just a hero because he survived the horrors in the dungeons of Baku, but because he also found the strength and the will to come forward and tell us about the things that they did to them, to him, and those who were with him. And as you well know, we still have hostages and prisoners in the dungeons of Baku. And on a daily basis there, at the top of CFTJ's agenda, we bring it up, we write about them, we follow them. We also follow how they are able to recreate their lives and find new meaning after the trauma they've suffered. All right, let's get to the panel. Our first person is Nicholas Koumjian. Nicholas Koumjian previously worked as counsel at the International Criminal Court from 2011 to 2013. He previously was a prosecutor at the International Criminal Tribunal for former Yugoslavia from 2000 to 2003, the State Court of Bosnia and Herzegovina, War Crimes Section from 2005 to 2006, and the Special Court for Sierra Leone from 2007 until 2012. Mr. Koumjian also headed the Serious Crimes Unit in East Timor from 2003 to 2005 and was the International Co-Prosecutor at the Khmer Rouge Tribunal in Cambodia from 2013 to 2019. Mr. Koumjian currently is head of the Independent Investigative Mechanism for Myanmar. Prior to his international career, Mr. Koumjian was a prosecutor in Los Angeles for 20 years. Mr. Koumjian, thank you for being with us.
Thanks so much for inviting me to it's a pleasure to participate in this conference. The topic of this particular panel is the challenges and innovations in international criminal law and how to navigate them. And I thought what I could possibly contribute is to talk about mechanisms. My current job is head of the Independent Investigative Mechanism for Myanmar. So mechanisms are a fairly new phenomenon in the international criminal law landscape. The first to be created was a mechanism for Syria. In December 2016, the General Assembly of the United Nations voted to create that mechanism. Why the General Assembly? Well, many people had been pushing for a referral of the Syria situation in the height of the war to the International Criminal Court. A referral to the International Criminal Court, as most of you know, requires the Security Council to vote in favor. And of course, it would require not just a majority of the Security Council, but also no vetoes from any of the 5 permanent members of the Security Council. Switzerland and a number of other states had written to the Security Council requesting referral. It didn't happen. In frustration, someone had the idea to at least create a mechanism to collect the evidence to be shared in the future with any court, international or national, that could have jurisdiction. So the General Assembly in December 2016 created this IIIM for Syria, which is still in operation. The second mechanism to be created was UNITAD, which our previous panel, the speaker from Kurdistan, spoke about. And this was a mechanism created in this instance by the Security Council itself. So obviously any decision of the Security Council requires political will and quite a bit of compromise or agreement among states that normally, very often, are not in agreement. I think one thing that pretty much everyone, and certainly all the members of the Security Council, including the 5 permanent members, were in agreement on was that ISIS was a threat, and ISIS needed to be prosecuted whenever possible. So the Security Council created a mechanism, UNITAD, with the idea that this would collect evidence and then share it with courts that could have jurisdiction over the offense. And UNITAD was in operation for a number of years, and as the previous speaker pointed out, it's going to close this week. And basically, you could correct me if I'm wrong, but my understanding is it lost the political backing of the Iraqi government itself. And one of the reasons for that is it's a United Nations principle not to share evidence when capital punishment could be imposed in the case. And because in Iraq, especially for crimes of ISIS, that was a possibility, it limited what the UNITAD could share with the Iraqi authorities. So the third, and so far the final, the last of the 3 mechanisms that have been created to date was our mechanism for Myanmar. And we were created not by the General Assembly, not by the Security Council, but by the Human Rights Council. So what is the Human Rights Council? It's a branch of the United Nations that deals with human rights. It's the highest body of the United Nations dealing with human rights. And in this case, the Council was really acting in response to all the reports of violence for many years against different groups in Myanmar, but in particular, the violence associated with the 2017 clearance operations, where the Myanmar military cleansed villages in Rakhine State in the west of the country of the Rohingya population. And it resulted in about 750,000 Rohingya, which was the majority of the Rohingya in Myanmar, fleeing the country to camps in Bangladesh. And our mechanism was created with the mandate to collect and analyze and preserve evidence of the most serious international crimes committed in Myanmar since 2011. So if it was 2017, these clearance operations, why give us jurisdiction back to 2011? Because the Human Rights Council was acting in response and in response to a recommendation from a UN fact-finding mission. And one of the points that the fact-finding mission had made is that what happened to the Rohingya was not a new strategy of the Myanmar military, but was consistent with how it had been acting over decades in conflicts with various ethnic groups and various armed groups in different parts of the country, but particularly in the north of the country, in Shan and Kachin states. So they thought it was important to capture that it wasn't just the Rohingya, but this was a situation that occurred throughout the country. So our mandate began in 2011, but they also didn't put an end point to it. So it continues. And when we had the coup by the Myanmar military, where they overthrew the elected government of Aung San Suu Kyi in February of 2021, that coup, while itself was not within our mandate. Why? Because our mandate is serious international crimes defined as genocide, war crimes, and crimes against humanity. And a coup, while it's against democracy, it's a violation of the right to choose your representatives through elections, etc., in a violation of the Constitution of Myanmar, it's not an international crime. But when it happened, we said, based upon the history of Myanmar, political violence, we would be watching closely. And it didn't take long for us to conclude, based upon what we saw of reports around the country, particularly about 6 weeks after the coup, of lethal violence being used against demonstrators in different places. So it all began around the same time in different places, with indicating a central policy. And we saw the systematic targeting of particular groups such as journalists or medical workers. We were able to reach a conclusion that this appeared, based upon this preliminary evidence, to be a widespread and systematic attack on the civilian population, and therefore crimes against humanity within our mandate. So since that time, we have been collecting evidence of these crimes. And collecting evidence for what purpose? Okay. Why mechanisms? Why not set up a court? Because our mechanism, we are not a police agency, and we have no powers of police. We have no powers as a prosecutor. We cannot arrest anyone. We cannot charge anyone. But this is a reflection of the constant, I would say, conflict in international criminal law between sovereignty of states and also issues about resources for courts, who's going to pay the cost of them, and the desire to actually see the worst crimes in the world prosecuted. So the Myanmar situation is another example where it appeared that a referral to the International Criminal Court was unlikely for political reasons. Myanmar has backers among the 5 permanent members of the Security Council. Wow, that went by fast. So, I see I have 1 minute left, so I'll wrap it up. But we're collecting evidence to share it with ongoing processes. So there is, as mentioned previously, an investigation at the International Criminal Court. We share evidence regularly with them. There's an investigation involving universal jurisdiction in Argentina, and we're sharing evidence. Recently, the prosecutor in Argentina, who was conducting the investigation, has made a request to the judge to issue arrest warrants against 25 individuals. That hasn't been decided yet, but it's pending. But his referral cited mainly the evidence that we had collected and shared with him. And finally, we have the case at the International Court of Justice, where we announced very early we received a request from the Gambia to share evidence, and we said we would share with both parties, so that the judges at the International Court of Justice, and this is a very important case involving allegations of genocide, would have the very best evidence of the facts, so they can base their conclusion on the best evidence about what actually happened. So thank you very much, given the time limitations. Thank you.
I just want to make the point that the 10 minutes is to open it up for you to finish what was left unsaid. Next speaker is Joanna Frivet, who, if you don't mind, may I call you a friend of CFTJ and a friend to me. And I met her recently in April. For those of you who are not aware, the Center for Truth and Justice did deliver a 100-page communication to the ICC in April, and Joanna and I were there together with, is Lala here? There she is. Lala, please stand up. I'd like to introduce Lala. You saw her on the video yesterday. Thank you, Lala. We took Lala to The Hague with us, together with Joanna. She is the sister of Guyane, who was severely mutilated in the Republic of Armenia due to the aggressive attacks on Armenia. The story of Guyane is one that is horrific. She's the one whose body was completely mutilated, and it was put on Telegram channels by Azerbaijan for 5 continuous days with 11,000 repetitive sites. Thank you, Lala. And Lala is one of the people who, by the way, our entire delegation did get their visas yesterday from the United States, and she is, together with Geram and others, going to be in Washington, D.C. to testify to the U.S. Congress. Thank you, Lala. Joanna Frivet is an international criminal law consultant with over a decade of experience advising states, international organizations, non-governmental organizations, and victims. She began her career in 2010 at the Office of the Prosecutor of the International Criminal Court and has since made significant contributions to various high-profile cases and legal initiatives. Her work has spanned numerous international situations, including more recent engagement in Kosovo, Venezuela, Nicaragua, and Armenia. In June of 2024, Frivet provided her legal expertise for the first communication to the ICC prosecutor regarding crimes against humanity committed by the Azerbaijani regime in Armenia. Joanna.
I know how this works. Thank you very much to all the CFTJ team members for having me here. As the judge mentioned, I had the privilege of supporting the work of the CFTJ in the first communication to the ICC. But before I talk about our work and the content of this communication, there's a very important point that I think needs to be made. There's a huge difference between what the evidence shows to be genocide and the international community's willingness to label it a genocide. That is why the genocide in Yugoslavia was allowed to happen, because it was not labeled a genocide as thousands of people were being killed. That is why the genocide in Rwanda was allowed to happen, because nobody called it a genocide until it was too late. And that is why, as we speak, there are many genocides currently happening, and we are not calling them genocides. And it is very likely that a number of these people suffering will never be deemed worthy to be called a genocide by the political leaders making these decisions. So with that in mind, I would like you to have a look at this map. So, as you see, this is a map of Armenia and of Nagorno-Karabakh. The parts that are in red are the parts that are currently under the occupation, and within Armenia, the unlawful occupation of Azerbaijan. These are dots within Armenian territory. We're talking about 200 kilometer squares in the provinces of Gegar-Kunik, Syunik, Vayotzor, Tavush, and Ararat. In these locations, the CFTJ has alleged that there is an ongoing genocide. And I'm saying ongoing because as of 2024, a few months ago, there have been villages that were demanded by the Azerbaijani states. They demanded that the villages be surrendered to them. So I understand that this is maybe controversial to many. We're saying genocide in Armenia. So before I talk about this, I want to say that genocide is not a matter that is referred to lightly. And it should not be. And it is precisely because of the weight that it carries that we need to address it with clarity. And in my experience, there's no better way of doing this than to look at the evidence itself. Before we look at the evidence, however, for those of you who are not lawyers, I would like to address what exactly is required for a situation to be counted as a genocide, legally speaking. So if we look at, okay, well, it's missing, that's fine. If we look at the previous jurisprudence in the ICTR tribunal, so in Akayesu, I'll read from you the quote of what genocide has been established to be. So, the systematic expulsion of individuals from their homes can constitute the infliction of conditions of life calculated to bring about the physical destruction of a group. What this is saying is that forcible displacement can be genocide. It's not always genocide, but can be genocide. Similarly, at the ICTY, it has been established in a Kurstic case that forcible displacement by itself does not constitute genocide, but can constitute a step in genocide. So why is it that forcible displacement in Rwanda and in Yugoslavia amounted to genocide? That's because it was combined with an intent to destroy. Now, the intent to destroy is really what we're looking for. And just to give you a flavor, a sense of what has been going on. From the evidence I have seen, if you look at the conduct of the Azeri armed forces, if you look at the conduct and the speech of the president of Azerbaijan, President Aliyev, I think that it is undeniably clear that there is an intent to destroy. From the language, from the course of conduct, from the actions that they've taken. It is as well impossible to ignore that this conduct has been deliberate and systematic in nature. These are a few statements that Mr. Aliyev has made, and he has made these statements at the same time as his troops were clearing the land of Armenian people. If ethnic Armenians do not leave our lands of their own will, of their own free will, we will chase them away like dogs, and we are doing that. Another statement. If you, ethnic Armenians, do not want to die, then get out of Azerbaijani lands. We will crush your head regardless of anyone. No one can protect you. Aliyev has also referred to ethnic Armenians as rats, devils, terrorists, enemies, fascists, human-like creatures, vandals, virus. The list goes on, really. There wasn't enough space. This has happened already. I'm not talking about a theoretical situation where people possibly may be destroyed at some point. We go back to the map, in the red part, this is a part of the world where there have been ethnic Armenians for thousands of years. All of you who have gone to the museums and understand the depth of this culture understand that there have been Armenians there for thousands of years. And there is today no more Armenians in Artsakh. It's gone. There are no more people of Artsakh. You cannot be, there's no more government of Artsakh, no more people of Artsakh. All of them are refugees. They cannot carry on their culture. They cannot, without their land, without their churches, without their history and tradition and the space to do it. Getting to the communication of the CFTJ. The Azerbaijani armed forces did not stop with Artsakh. They have carried on the same policy with the same intent within Armenian territory. In all these areas, in all these red dots, Azerbaijani armed forces have taken high positions over the villages, over weeks, have indiscriminately been shooting at people, villagers, farmers, kids going to school, so much so that those who could leave left, and those who couldn't stayed. After a while, usually it's followed by music, propaganda, attacks in the middle of the night where they would come in and forcibly remove people. Those who could not leave, the elderly, the handicapped and other people who stayed behind, haven't been heard of. They're all enforced disappearance cases. They're all somewhere either dead or within custody for no reason at all other than the fact that they're Armenians and they were there. This is what we're dealing with in Armenia right now, and it's continuing. This is why this communication was submitted to the ICC, and I think I will stop there and really encourage you to go and look at the evidence, look at the communication yourself, and make up your own minds. Thank you.
So Joanna and the staff of CFTJ and I worked on this, but I don't think I can make the case as well as Joanna made it, and I really thank you for that. There's something very valid about a non-Armenian looking at the evidence and seeing the truth. That's why most of you are here, hopefully all of you are here. The communication that Joanna talked about is on the CFTJ website. It's a 100-page document. But if you go to the CFTJ website and you look under reports, almost everything we've discussed has been reported in detail with evidence. So I encourage you to do that. Our next speaker is Dr. Dov Jacobs, who is a French international law and international criminal law expert, counsel at the ICC and MICT, and founder of the Strategic International Legal Consulting, a consultancy specialized in ICL, human rights, advocacy training, and capacity building. Heiss currently is co-counsel for Mohammed Saeed at the ICC, and formerly was on the defense team of the Laurent Gambo at the ICC and Felician Kabuga at MICT. He has also been involved as an amicus curiae in the Afghanistan and Palestine situations at the ICC, and is an associate member of 9 BR chambers in London. Jacobs is a founding member and former vice president of the International Criminal Court Bar Association, and teaches in a number of universities, including Leiden University, Sciences Po, and Université de Lille. He has published extensively in the field of international law and international criminal law, including in leading commentaries on the Rome Statute in French and English. Thank you, sir. Come on up.
I'm like you, I'm putting my own timer. Okay, thank you. It's a great pleasure to be here. Thank you for the kind invitation by the center. You might say I say this every time I'm invited to a conference, but I honestly can say I don't remember being so warmly welcomed by a community as I have arriving here. So it's my first time here. I hope it's not my last, and thank you for the warm welcome. So the topic, as Nicolas pointed out, is quite broad, and navigating the challenges and innovations of ICL. So it's been difficult for me to narrow my presentation. I'm going to try and give some pointers based also on the discussions we've had since yesterday. ICC was mentioned a number of times, universal jurisdiction. So the idea is to open the discussion rather than give answers in a strict sense. So I thought, especially reflecting on the discussion yesterday, that there were 2 levels in which I saw this idea of navigating challenges. One is relating to the topic of the conference, pathways to post-conflict justice. And the judge yesterday in his video statement already expressed this, a tension that can exist between international criminal justice or criminal justice and post-conflict objectives like peace or reconciliation or truce. And I think that's something that we have to keep in mind in the broader policy discussions, because we all tend to see those issues from the narrow spectrum of our expertise, our practice at the ICC, our practice at the ICJ, at the mechanisms, etc. And it's often difficult to see this, what I would call balance of priorities, because we all like very nice speeches, and I always found the UN has changed a little bit on that, but the general idea I always had with the UN and transitional justice is what I call the cocktail approach to transitional justice or post-conflict justice. Just talk about truth, reconciliation, justice, reparations, put it in the shaker, shake it, pour it, put a little umbrella and it's done. We have transitional justice. And obviously we all know that's not true, from our own practice. And even though we know it's not true, we tend to forget it's not true. When we talk about all these, and we have this illusion that we can reconcile all of those objectives all at once, which is not true. So that's, when it comes to international criminal justice, it raises difficult questions about prioritization, about, in a post-conflict situation, you have a call, for example, it always struck me, how fast you have a call for the ICC to intervene when there's an ongoing conflict. The idea that it brings hope to millions of victims, and there was discussed yesterday with the term expectation for victims, but I always found the timing weird. It's as if a court is going to stop a conflict. I don't believe so. It doesn't happen domestically. That's not its job. And this idea that, because an example I always had in mind, because the Security Council, there was a veto when they referred to the ICC, the conflict in Syria was allowed to continue. Like a refer to the ICC was going to end the conflict in Syria. And that it's a veto. We can agree or disagree on the veto itself, but the idea that because there was a veto at Security Council, the conflict was allowed to continue, I think is a bit simplistic. And it's the same with funds. What do we prioritize after a conflict in terms of what kind of mechanism will bring the kind of reconciliation? And sadly, international justice is slow and expensive and might not be the best option when it's done internationally. And I know it's a difficult thing to hear, but sometimes you wonder if immediate justice, relatively immediate justice at the ICC, is better than a more prolonged process domestically, but where there's local ownership in terms of training, capacity building, etc. These are difficult questions. But so that's a broader meta considerations I was thinking about. And then you have the ICL perspective, International Criminal Law. And here I just want to throw out a certain number of balancing of priorities that we're faced with, whatever our position, defense, prosecutor, etc., at each step of the proceeding. And unoriginally, we often say it's political, but it's also a question of money. There isn't money for everything. And there's a prioritization, which is sometimes political, of how the money is distributed. So choice of situations. I know there's a panel tomorrow, I think, on why Armenia is not enough in the media and why certain situations get more money than others. And it's a real question. I mean, if you look, and again, nothing I'm saying is a denial or minimization of crimes in certain situations. I shouldn't have to make this caveat, but I'm making it. But of course, what's happening in Ukraine is important. But I understand those from the DRC and some other situations who are saying, why so much money is thrown at Ukraine? There's still so many crimes committed where we come from, and why we should have a more balanced approach. Just because it's in the media doesn't mean we have to throw so much money at it. Also, there is this, so there's a decision by the prosecutor of the ICC where to distribute funds for investigations, etc. And that's a real question. In terms of selection of situations also, one of the difficult questions which has arose recently is the expansion of the ICC towards non-state parties. I'm not going to open the debate. We can have it if you want. I have strong opinions on that. But besides the debate on jurisdiction of the ICC vis-à-vis non-state parties, this has concrete consequences on the capacity of the ICC to function. Because I think we can all agree that even if it's legally possible, it creates problems in terms of cooperation and actually getting accused, which you can have trials on. The result is next year, I'm on the Said trial. Once we turn our trial, there are no more trials at ICC. This is the International Criminal Court. There will be what I think is a joke of a proceedings in absentia for Kony, but that's a different matter. But there will be no trials. This is a court. And we have the prosecutors zooming around the world, in Gaza or Palestine and Ukraine, promoting positive complementarity, but there are no trials. And the irony here, and I can say this because I'm not part of the institution, is that the reasons ICC branched out to non-state parties or to Ukraine, Gaza, etc., is to also respond to the criticism of being a racist court, only prosecuting Africans and from African countries. But the only way that the ICC can get more cases tomorrow is by going back to those countries. Because the ICC is going to I think, maybe I'm being too cynical, but there will not be a Russian general or an Israeli general in front of the ICC tomorrow. So the ICC wants to have cases and show the world and the ASP, which is giving the money, that it's working. It has to have accused, and the accused that are easily accessible are low-hanging fruits from, warlords from DRC or Central African Republic, etc. But that's a different matter. A second prioritization is the evidence, and we've discussed this a lot. And I think that's a major issue because, there is this tension between not enough evidence for certain aspects, but there's also we're in an era of a lot of evidence, where evidence is being collected as the crimes are being committed in Ukraine and other places. And it raises a number of issues of, I'm talking from a lawyer's perspective, not just defense, but also prosecution should be concerned with that chain of custody, tainting of the evidence, etc., where volume doesn't mean quality in a criminal context. And I know a lot has been done by the center in terms of ensuring that, but it still raises questions, which I have, for example, for all the commissions of inquiry, of accessibility, labeling of the evidence, how it's made available to the prosecutor, but also the defense, how the sources, and I know there are tensions which exist between the confidentiality of sources for legitimate reasons of protecting victims who are talking, but also the job of the prosecutor is to check the sources and test the evidence, and the job of the defense is to be able to verify the source. And often there is no real good answer to how we balance all these things out. I'll mention one last priority issue is the trials themselves. I think that there is a frustration with the speed of international justice, and we're constantly having this discussion of those trials are too slow, and in certain aspects they are. But we shouldn't have the expectation that they can go too fast either, because I think legitimate justice is a justice which allows the prosecutor the time to build a good case, and these are complex cases, but also the defense to challenge the cases and challenge the evidence, etc. So, claims to speed should be understood in this context, where you can't have a good trial, a legitimate trial, without a fair trial. And I say this, and I've always contested this idea. This is not a defense perspective. I'm often invited as a defense lawyer. This is of interest for everyone in the system. The rights of defense are enshrined in the Rome Statute as human rights. And so I know this is not what you're saying, but I often get this thing, but you're just doing the defense perspective. No, it's everyone's perspective. It's a human rights perspective, which should be shared by everyone, prosecution, judges, and defense. I think I'll stop here, 10 seconds before my time. Thank you.
So, for those of you who don't know, my day job is actually being a judge. I'm a trial judge. I just want to point something out. My legal career before I got on the bench, which was 10 years ago, was being a criminal defense attorney. All right? And where are all of my CFTJ staff and volunteers? Stand up. Come on, you can do this. They're like, should we? Should we not? Should we not? All right. So I will. The reason I make them do this. Thank you very much. And by the way, 1, 2, 3, 4, 5. Except for Misha, who's really tall, who's from California, they're from Artsakh, okay? So before the fall of Artsakh, a year ago, we did training in Artsakh as well as in Armenia. My Armenia trained volunteers and staff, I think, are outside making things happen. And we have spent days, weeks, months, and years learning about chain of custody, admissibility, non-hearsay evidence. So I just want to point out that, and these are new concepts to Armenia, because we had to create terminology to basically be able to learn and explain this in Armenian. Thank you very much. And the reason I bring this up to all of you, to the panel, because I do want to ask a question is, thank you. You can sit down, thanks. Is because there's a limit to how much evidence an organization like CFTJ can gather, all right? avoiding re-traumatization, for sure, getting forensic evidence that supports what the witness is saying, which is why I'm going to come back to Nick here to ask about how do we get to the next phase, because you all know the absolute evidence ultimately is in Azerbaijan. And Armenia does not have diplomatic relations with Azerbaijan because of the wars that we've been in since the late 80s, early 90s. And there's a limit to what a non-profit civil society organization can do. Okay, so this is the preamble to the questions that are coming. Okay. Philippe La Rochelle, I would like to also say you're a friend to CFTJ and to me. Thank you very much. And Philippe has represented the interests of the Armenian POWs in Geneva, April of this year. He went there and was before the Commission Against Torture. And I'll let you talk about that, but I'll give you a bio about him. Mr. La Rochelle has been a key figure in international criminal defense since 2001. He is currently serving as co-counsel at the International Criminal Tribunal for Rwanda, ICTR, in the defense team of Jérôme Bikompaga. La Rochelle's legal career began after he was called in the bar in 1998, and he initially joined a major law firm in Montreal. In addition to his work with the ICTR, La Rochelle has been involved with the Special Tribunal for Lebanon, very near and dear to my heart because I am from Lebanon originally, and briefly with the International Criminal Court. He founded La Rochelle Avocats in 2018, a litigation boutique based in Montreal. La Rochelle's previous roles include partnerships at Roy La Rochelle Avocats Inc. and Ogilvy Renault LLP, where he specialized in commercial litigation. His extensive experience highlights a dedication to both international justice and local legal practice. And Philippe is the example that I invite all of our first-timers in Armenia to follow. This is our third conference, and this is the third time Philippe has been in our conference. Thank you very much.
Thank you, Gassia. Even if my wife is here, I want to tell you how much I love you, you and the organization that keeps inviting me here year after year. It's a real pleasure to see friends again and to see how your passion and your dedication to justice for the victims of Harza keep taking new forms and new initiatives and bringing new important people to these conferences. And as you can see now, I can say Harza, right, after 3 years. I can see also that I've been somehow knighted. There's now a particle to my name. I'm no Canadian noble. I'm a very layman person, and I thank you for that honor. Armenia definitely needs you more than the ICC, maybe, and you need to continue to do all what you do. You have so far certainly achieved far more for these victims of Harza than the ICC has done. We hope it changes and it goes in a different direction, but the fact that you invite international criminal law rock stars in these conferences. We have Mr. Rap, Bruce Springsteen, present with us and giving us a very interesting lecture, I thought, this morning on forced displacement. We had last year Chile Obwe Osuji, Lenny Kravitz maybe of international criminal law, who also gave us a very interesting lecture. We had yesterday Paulina Macida, Madonna of international criminal law. So we see that you managed to create an interest that sustains over the years. And they come and they hear you, and they hear everything about Harza and about its victims, and also they taste the hospitality and the absolute warmth of Armenian people, and I have no doubt that they will keep coming back. So why did you invite me this year? For the third time, hopefully to again find something interesting to say. And now you're asking me to help you navigate the challenges and the innovations of the ocean of international criminal law. And things are changing, things are improving. Armenia has a boat now. It's a landlocked country, but it has a boat. It ratified the Rome Statute, so to some extent it can start moving. Where should it go, I guess, is the question that we are exploring together, and we're trying to find answer. In this very vast ocean of international criminal law, has Armenia left the shore, or is it about to? Is it, I guess it's looking for the Valhalla of international criminal law, the International Criminal Court, this island, or this boat, I don't know, where it hopes to get in touch with Mr. Karim Khan. It's not clear. I have to say myself, I've been doing that work for quite a number of years. What can Armenia get from the International Criminal Court? What can Karim Khan offer? He who is currently at the helm of this boat. Where to go? How to find them? What do you need? What tools? Evidence, of course, is key in this endeavor, that's for sure. And for some extent, the ICC now has been in existence for over 20 years. It felt a bit like the Titanic, right? Where they were looking for icebergs with flashlights at the front of the boat. Now we have some sort of a mapping exercise, or maybe some directions that can be followed in trying to find avenues for cooperation, avenues for complementarity between Armenia and the International Criminal Court. So one of the path, I guess, where you can find the ICC and maybe find interesting food to feed Mr. Khan is definitely through complementarity. I think complementarity is both a ditch and a bridge. I think it can be, it can take several forms, and you need to find those pieces that will make a puzzle interesting enough to Karim. And this policy from the Office of the Prosecutor that has 85 pages. Personally, I prefer to read indictments from the prosecutor than policies, but that's a personal choice. I'm a defense counsel. I guess I bring a bit of that here, like Dov, but not completely. I want to stress also that we're here not so much as defense counsels, but as people who are looking for justice and new, innovative, and different ways of finding justice for the victims of ARTSA. So there's 85 pages. I started reading. I admit, I confess, I stopped. I had to stop. So you have the first page. Then I will take you to I like images. I think it has a lot of images, actually, in that policy. And because it became a bit burdensome to read it, I started going to the images. Did I press the right button? No. There. This is page 26 of the Cooperation and Complementarity Policy of April 2024 of the Prosecutor of the International Criminal Court. This is extraordinary. They have some sort of we know they received money from the UK, I think, to improve their evidence handling techniques. So now they seem to have some sort of a Star Trek bridge, which allows them. I was trying to look for information about my case there, but I was not able. They were very careful, of course, in withholding confidential information. So I don't know. I thought that was an interesting image to share with you. You know, expectations. We were discussing expectations yesterday. I think that may. I don't know if you show that to victims when you're on the ground to try to explain them the work of the ICC. That may create actually expectations in terms of what's going to happen to the horror stories that they went through. But this is innovative anyway, I think. But more seriously, I think that this 85 pages document is worth reading for people who are looking for exploring new ways of cooperating, because over and beyond the nice images of Karim and the Star Trek deck of the OTP in The Hague, there are a lot of possible ways that could open up deepened cooperation between Armenia and the International Criminal Court. So, because I abandoned the idea of reading the whole cooperation book, except a few extracts which I will give you later, I decided to do something because I really needed to prepare and I was not ready, and Stephen Rapp is here. Like, you don't want to look like a fool. You know, your defense counsel is a prosecutor. So I asked ChatGPT to help me. Thank God. There's like now innovations before preceding the Star Trek desk. And I asked him, I just put him the question, like, help me please find new innovations and what are the challenges in navigating international criminal law. The problem is that ChatGPT seemed to be under the assumption that Armenia had not yet signed the Rome Statute, so that was really complicated. I had to abandon that idea. I'm not even submitting it, I'm not using it. It was not clearly going the wrong direction. So really, you're left to yourself in this endeavor. Pretty much like Armenia at the moment, in terms of finding ways. But I think there are ways. And again, I stress. I think there are ways, and you find, for example, the extraordinary work that has been done by the CFTJ has to be somehow relayed by Armenia, and these investigations must continue. And I have a small example that maybe can inspire Armenia in going forward and trying ways to anchor itself to the ICC and at least prepare the ground for a day where the political conditions will be such that there will be a greater interest maybe in pursuing justice at the International Criminal Court here. So it's precisely that, right? Like don't ask what the ICC can do for you. Just ask what the ICC can do. Period. It's a difficult question enough. I think if you can find an answer to that, then you already have gone far in trying to find ways. I must say that I was deeply moved by hearing Mr. Stepanian earlier on. And I say, when will be the day where that man will be put in front of an ICC investigator? And maybe that's where small steps can start to be taken, to have a cooperation agreement between Armenia and the ICC, just to start investigations, just to make sure that these interviews that are performed are just up to ICC standards. So you will gain on so many levels. People here will do it in a way that can be meaningfully used by the ICC after that. And you will get ICC people to hear what these stories are and echo that in the office of the prosecutor. They will get back, guys, what are we waiting to go there? We must assist these people. We must help them because this is over 100,000 people forcefully displaced for their homeland. We need to do something about that. So build it. They will come, I'm sure. You start, you share that evidence with them, you start going further away. There must be so many people that still need to be interviewed and that can still be put in contact with the Office of the Prosecutor of the International Criminal Court. And my time is up, but one other idea that I thought maybe could be of some use and should be put in effect is, for Ukraine, they created this register of damages. So why not do the same here? You have 120,000 people who lost homes, cattle, relatives, goods, memories, and other precious things. Why not create that registry? That's a small step where at least, and you can do it with Paulina. She works with victims, so she can maybe even use that idea for the ICC to create a register of damages so that when reparation time comes, it doesn't take 6 years to send 750 euros to the victims. So the innovation can go both ways. There are ways, because you are so well surrounded with people with so many great ideas that they can also help the ICC improve and get better. So these would be, just like Dov, a few ideas I'm throwing around, and I hope that I will come back next year to discuss again. Thank you very much for your attention.
I think Philippe just signed us up for our next conference next year, Koumjian. So get ready. All right, let's get down to business. Nick, let me ask you a question. So the things that you talked about are the mechanisms that have been created. It has nothing to do with the ICC or otherwise, for the purpose of gathering, doing investigation. That's the work you're all doing right now, correct? All right. Where are we? What's our shortfall? Why? What do we do? Because, like I said, I mean, Center for Truth and Justice is a community-funded, community-organized nonprofit with the goal of establishing the tradition that evidence needs to be collected from an objective perspective. All right. But that's limited. We can only do so much. We can keep gathering testimonies, obviously. But the kind of work you're doing gets into the details, the foundations of where the true evidence is, which is what's needed for ultimate prosecution, if you will, if you get there. So where are we falling short? What can we do to get other mechanisms through the UN, through others, so that it's not just being done by a community-based organization?
Well, in Myanmar, the mechanism, we work closely with civil society organizations, many of which are concerned with accountability and gathering evidence of what happened in Myanmar. But our model is, we try to explain to them as much as possible, we like to have direct contact with those that have first-hand information about what occurred. And we do try to meet with them and take in-person statements from witnesses and those who have first-hand information about what occurred. And we actually have the witnesses sign an affirmation that this is true, what they're saying to the best, according to their conscience, honor, and belief. We use the exact words that witnesses are required to use when they testify before the International Court of Justice. So our hope is that by taking this evidence and preserving it, it will have high forensic value in whatever court eventually receives the evidence. And the International Criminal Court, we're specifically mandated by the Council to cooperate closely with them. And we do. We have our team that works on the Rohingya speaks weekly with the ICC team, and we share our evidence with them. We even have done a few joint interviews with them of sexual violence victims. And that was because we don't want to put a person who's been sexually violated through having to give multiple interviews to different institutions. So it makes sense to us that we do it together jointly so both of us can use that information.
So I guess my question really is, because all of the mechanisms you talked about, the methodology is something everyone's trained in, our team. We don't do anything without consent forms. In fact, our testimonies are not available online. They're completely confidential. The little clips, you weren't here yesterday, we'll play it for you sometime. But the little clips that we put on was with the full consent. So we follow those internationals. What I'm saying is you're able to share your evidence with the ICC. ICC is a partner with you in collecting evidence. That's the part we're missing. And I'm not necessarily saying the ICC. How do I get an internationally mandated institution to partner, not even with CFTJ, but just to partner to do this work for Armenians?
I wish I had an answer to that question. I forgot what I was about to say. You said something about about consent. I think that's extremely important. And so when we collect evidence, we don't then just have the right to share it with whoever wants it. And this is something that we spend a lot of time on with each witness that we interview, trying to explain to them the difference of the International Criminal Court the court in Argentina, how they would treat their testimony, the International Court of Justice. Do they consent? If we share it with the International Court of Justice, it means the current authorities, the junta in Myanmar, gets the evidence. Are they comfortable with that? And if they say no, then we would not share that evidence. Actually, even if they say yes, currently for the International Court of Justice, we're redacting all the identifying information from the witnesses because I don't feel confident that the witness will feel the same next year. Because the situation is so fluid. And perhaps, if next year we may make a decision to go back to them and ask again, do you want your identity revealed? But at least at this time, we feel it's in the interest of caution better to redact all of the identifying information.
Just to let you know, our evidence has been used in the ICJ case. So CFTJ's evidence is being used wherever there's any form of proceeding. Joanna, where do we go now? What's next? You know what CFTJ has done. You know the status. I just want to I want to put this caveat out. Everyone is aware that the Armenian government is actively pursuing the peace process, and the Center for Truth and Justice is in full support of it, with the full understanding that pursuing justice, it does not contradict pursuing peace, but in fact it has to go parallel, hand in hand. Center for Truth and Justice says this over and over again. But ultimately, you've met some of the victims, and one of the things we have is that they say to us, is Margarita here? Margarita, I'm going to have you stand up. Margarita is from Hadrut. In 2020, when Azerbaijan occupied Hadrut, she and the entire population of Hadrut was displaced into Armenia, and they could not go back after the ceasefire because it was fully occupied. She has a registered organization in Armenia that represents the Armenians of Hadrut. And every year I see Margarita and I say to her, how are you? And she has a very sad face on. And she says, it's taking so long. I don't know what's taking so long because the pursuit of justice takes a long time. But you also know we've taken some steps. What do we do next?
I think that it's very important, the work that you do, because you're in many ways the only ones who are able to push the issue of accountability the way you are. Because the government is currently caught up with the peace negotiations, there's only so much they can do. So, in many ways, you're a non-state actor that now has to carry on, the burden of a whole people, the people of Nagorno-Karabakh and the people of Armenia. And pretty much right now, I'll say this, and it will sound probably very, very strange, but you have to try everything and see what sticks, right? It's a game of legitimacy. You do your work well. You do your work credibly, with the proper legal expertise, and you knock at the doors. You knock at the UN mechanisms. You knock, you go for POWs. You go to the conventions. You go to the ICC, and you really push to see and to make it happen. To try to engage people in your cause. Because you can't do this alone.
So what do you have to say, because we've discussed this, what are we doing with the ICC now that we gave them a communication? What do we do now?
You engage with the states. My understanding is that the ICC is swayed by the states, right? They can't necessarily push a specific issue, but yet I worked in the Office of the Prosecutor for a while, and I know that every Wednesday, first Wednesday of the month, there's a diplomatic briefing. All the states sit in a room and ask questions. And the states ask questions to the ICC Prosecutor, and he cannot give the same answer every week to an issue. So it's really a matter of things will move faster if there's an interest in the states for it to move faster.
State parties.
State parties of the ICC, yes.
And it doesn't have to be Armenia.
No, it doesn't have to be Armenia. Of course, and we've spoken to many of the embassies in The Hague. Of course, they say, Armenia isn't pushing their own ball. Why should we? and it's a fair question, I think. But I think many of the states who are also in favor of a peaceful resolution to what is an ongoing conflict understand the limits of that and are willing to support, with the understanding that the crimes keep on being committed, with the understanding that the same intent with which Azerbaijan went into Nagorno-Karabakh, and that's maybe something I should have said, it's very interesting, is that the Azerbaijani parliament has issued decrees where it refers to Armenia as Western Azerbaijan. Right? Let that sink in for a minute. So this is not going away. So there is very much this need of engaging other states in your issue at every level, not just the ICC, the European Union, wherever you can go, wherever you can get. And not necessarily pushing for, as we've heard, the Americans said that they would stop it from happening. It hasn't happened. And it's complicated, right, in the current global situation. It's very complicated. And in the absence of that, what you can get is you can push for victim protection, you can push for an attempt at bringing accountability, proper recording. I think that's a fantastic suggestion, having a victim's record of what's going on and really try to get people involved in your issue. And with the ICC, I think accountability. The ICC is interesting because that's the hard bit, right? The UN mechanisms are in many ways record-keeping, proper process and all that, but there's no warrant of arrest. It's not something that Aliyev will sit down and think, well, I'm not going to do that because somebody's going to issue a report saying that, because there are reports already. There are many reports from so many agencies. So you have to push.
So just a minor comment, because you talked about with the communication we did that ultimately when you're talking about genocide is the intent of the state policy, all right? I'm asking everyone to please read some of these reports, all right? The policies of Azerbaijan have been very clear since the late 1980s. It's in writing of what they plan to do, what they want to do, and how they are now calling Armenia Western Azerbaijan in order to justify occupation and removal of the rest of the Armenians in proper Armenia, in the Republic of Armenia. So this is reality.
Sorry, one more thing I want to say is that this isn't just happening for the first time. We're talking about, post-1915, where out of 1.5 million people, all the Armenians that are left in the whole world are descendants of 200,000 people who survived the genocide. On the way to here, I went to the military pantheon, and I saw a hill covered with 4,000 graves of young men who are descendants of genocide survivors who were killed in the 2020 war. This is a generation that survived genocide and is not making it, right? And so are all the people of Artsakh. They're all children of survivors of a genocide. This has a special gravity because of that fact. And I think that when you're aware of that, then you call in to the urgency of the situation. You could get people to sympathize, to empathize with the cause of the Armenian people.
I'm an example of a survivor of genocide, descendant of survivors of genocide. All right. Dov, may I call you Dov? We have to make sure that you two become a friend of CFTJ on a first-name basis. From a perspective of defense attorney, what have you seen? What have you experienced? What should we look out for? So I'll just give you a little caveat. When I was at The Hague with Joanna filing this communication, my legal career was always a defense attorney, and here I was seeking prosecution. It felt very strange, but I was seeking prosecution because that's where the truth lies. So from a defense perspective, how do you see our case? The case of Artsakh, the case of forcible displacement, the case of 150,000 refugees. We'd like to hear the other side for purposes of argument, because we know what Aliyev says. He simply denies it. He says none of it is true. This is their old historical land. Do you feel like being a defense attorney right now? You're on your own. No co-counsel here.
Okay. First name basis. Again, the caveat I have is that there is no... I truly believe that a good prosecutor and a good defense lawyer are applying the same methodologies and doing the same job. And I think that, for example, the Office of the Prosecutor's ICC would be smart to hire me, because I've shown in court that I can destroy their cases and I know how to build the case. So it's not so much a devil's advocate thing, it's a question, and I won't lie, I started reading the report, but I didn't finish.
You fell asleep.
I didn't fall asleep, I just didn't, I discovered it too late in my preparation to come here, and I found it very interesting. So I think the evidence issue is crucial, because maybe it's not the... I'm not saying this because I'm a nihilist or a relativist. I'm saying that in court, I'm stating the obvious, but it's not what truth is what you can prove beyond a certain standard. And time and again, I've seen the prosecutor put evidence forward which does not prove something beyond reasonable doubt or beyond a certain standard. And there can be reasonable disagreement on that, but it's reasonable disagreement, And it's, the Bagbo case was mentioned before. A lot of people said that I was always very annoyed by some reaction from people from the outside of the case who said that shows the OTP did not work well in gathering the evidence. I was on the case for 10 years. I saw the hundreds of thousands of pages of evidence. I think maybe we have to accept there is no evidence. It doesn't exist. There is no evidence to support the prosecution theory. Full stop. And that's never considered. When there's an acquittal, it means, oh, the OTP has to work better to get better evidence. But maybe there isn't. And I think that's, I'm not really answering your question, good lawyer. But I think it's a broader discussion. If I may, just one point, reacting to what Nicolas said and the question. There's always a dialectic between the nature of what you're gathering and what you want to prove. And the difficulty that everybody's facing is, we want to, I'm moving away from ICL, we want to establish a historical record of what happened. And the standard for that is lower, and it should be lower. And, truth commissions, commissions of inquiry, and we have to wonder whether, at some point, the attempt to meet certain ICL standards is not to the detriment of doing the job for historical purposes. And I was thinking in Sörgården that you mentioned this forest and tree metaphor, which I've heard forever, whether you have to prove just a handful of trees. And I would, from an ICL perspective, I hate that metaphor, because the burden is on the prosecutor. There is no forest. That metaphor assumes there is a forest and you just have to prove a handful of trees. But from a procedural perspective, there is no forest. The starting point is nothing. Then the prosecutor has to prove it. And so I always find it disturbing, but it is an important metaphor from other perspectives. Because if you have a broader objective of establishing the truth in a broader sense, establishing the reality of human rights violations, and you're not burdened by the ICL standards, you have more flexibility. The question is, to answer with Nicolas, you're stuck between a rock and a hard place, because you're trying to achieve a lot. It's quite ambitious. You want to document this, but you're not going to suddenly exclude one of the videos, a harrowing testimony of a victim, because technically it's some hearsay, or you're not going to exclude that either from your database, even if technically you might consider it might not meet the standards in court. And so I don't know if internally you have a system, or even Nicolas, you have systems to create a hierarchy or labeling of evidence that meets certain standards, or you just let OTP or whoever deal with that in court and the defense to challenge it. I return the question to you.
I like it. Just for you to know, we're stuck between many hard places and many rocks. Because one of the things we're doing is, when we first started this work and we were training the students and the law students and the lawyers to collect testimony, this actually happened, and to my chagrin, I would say to them things like, when you're taking testimony, make sure they speak in their own dialect. And I would get back, well, they don't feel comfortable, they want to speak in Russian or they want to speak in proper Armenian, and I'd say, no, I want them in their kitchen, in their village, on their stool, in their own dialect. And the example I would give is, what if 50 years from now, Artsakh didn't exist, just like my grandmother's town does not exist. Okay, there is no testimony taken from my grandmother in order to know how she lived. Unfortunately, 3 years after that training, Artsakh does not exist, and so now we do face the fact that what we have gathered is going to be for historical purposes. We started with the goal of gathering evidence for prosecution. But we had to do the bigger picture because there is this ongoing current fear of what's going to happen to the Armenians, just like Joanna said, and that fear is current today for the Republic of Armenia. So we try to use our evidence in whatever ways we can, including documenting our history and our truth. Philippe, I'm going to ask you to actually please talk about, because you're very aware of the situation with our POWs. You actually presented on it. Would you like to take a few minutes and present on that, of what you did in Geneva and what you talked about? I can actually play it, but I won't, because we have you recorded.
When we went to Geneva to present submissions on behalf of the CFTJ, the treatment of these prisoners of war had already been documented, but most importantly, they were the subject of individual complaint before the Committee Against Torture. So we were in very conquisted land, maybe. But I have asked, because in the end we decided to use this image before the Committee Against Torture that I'm projecting there. And this image has a very interesting story, and two things is, you think you know a case, and then 24 hours before being the Committee Against Torture, some Misha, not to mention him, there's this image, and then I said, what image? And it's, this image was meant to be on a stamp of Azerbaijan, and they were going to issue that stamp to send letters all around the world with that image on it, on their envelopes, on their postcards, and what you see is so disgusting. It was actually prohibited by the International Telecommunication Union. Did you know that the International Telecommunication Union actually has the power to stop the issuance of stamp when they reproduce images like that? Anyway, I learned that, and I learned also that always ask the questions to Misha. He will find you a good answer and a good. So I like to think that this created quite an impact in the Committee Against Torture to accompany our submissions, because there is, I will use what Mr. Rapp said, the linkage between the torture taking place in Baku's prison and the request to issue a stamp like that. There is a link. There is a direct link. And this is how you must investigate. And what's the next step? What was the request to the artist who created an image like that? What exactly they wanted to project on their stamp so that the final product turned out to be this man spraying Artsakh and the rest of Armenia, and the idea that they were so bold that they wanted to put that on a stamp and send it all around the world just baffled me. So this is the Committee Against Torture. You think Karim Khan doesn't have a lot of time for attention? These people have even less time to listen to you. So and there were a lot of people coming from Armenia that had also very powerful things to do. So what was more important than the few minutes where we were able to engage with the members of the committee were those very detailed written submissions where the case for the prisoners of war was made in details. And it became so powerful that the Committee Against Torture could not ignore it, and you see it in their report. You see it in their report. When you have the evidence, then it's a very powerful tool that you can use before international criminal courts, but that you can also bring to institutions such as the Committee Against Torture to obtain results and to snowball everything you gather before the court, but before local courts where these people, and that's why I think I've mentioned this to you, but it's important also. These prosecutors, they think always about evidence. We defense counsels are different. We like the money, right? So I think it's important to have a registry, because for these people to impose sanctions, monetary sanctions, and to put a figure on what they lost, and then to explore other accountability avenues that are more and more popular, trace the assets of those we think are responsible for that, and get freezing orders, and work in collaboration with the Office of the Prosecutor and their beautiful Star Trek desk to maybe incorporate some of those investigative avenues in their work and in your own work. So that's what happened before the Committee Against Torture. We actually circulated that image to all of the members of the Committee Against Torture before we started our submissions. And I didn't have enough time earlier on, but on my PowerPoint there is an example of cooperation between the ICC and Guinea. So they held trials in their own country, but they have this memorandum of cooperation, 5 articles. We will come and train your people. We will share evidence. It's just at the step of investigation. It doesn't commit you to anything in terms of complementarity or else. It's just to a country and the Office of the Prosecutor with all its expertise, with all its resources, assisting a country in seeing a path to justice and accountability. That path ended up with trials in the country, but at least it created, I think, it put things in motion, it facilitated exchanges between the prosecutor and the country in how they were gathering evidence, and there was a clause in there, which is very interesting, where the prosecutor always keeps the power to bring things back to The Hague if the country is no longer willing or able to prosecute the matters which fell under the jurisdiction of the ICC.
Wait, did you say it's a memorandum between a state a country and OTP?
Yes.
But it can't happen, that memorandum of understanding can't happen without the state party signing the memorandum?
Yeah, of course. It's an agreement, a negotiation. This is a negotiation. You put whatever you like in there.
But I'm trying to define the parties.
It's the state party,
right, okay.
Guinea, and the Office of the Prosecutor.
Got it.
And it concerned mostly cooperation between them and a path going forward to accountability, basically. And I think it's an interesting model that could be arranged differently for the purpose of securing an agreement between Armenia and the ICC. And I understand that there are, peace talks and that there are other imperatives, very political, but at the same time, to have a gun like that, loaded with the ICC, where we are investigating in cooperation with you, even if we have no idea where it's going to lead us in terms of complementarity or where these trials are going to be held and when. But it's interesting to at least show that you start working with the OTP, even if they are small steps, and God knows, maybe one day you have warrants of arrest that you cannot execute, and there you really need the work of the ICC to implement these warrants of arrest around the world, because you're blocked, because obviously you cannot go and arrest people in Azerbaijan. So these are creative ways, maybe new ways, novel ways of trying to work with the Office of the Prosecutor, and this is mentioned in their 85 pages policy that I did not read completely, but there might be other ideas that I didn't find that could be incorporated in an agreement like that. Thank you.
Go ahead.
I find interesting from Joanna and Philippe's answer is a kind of elephant in the room of the official position of the state. Maybe this is the right or wrong place to say this, but it seems, of course you can approach other states, but it doesn't really look good if the state directly concerned is not doing a self-referred. That's the bottom line. And if it's not doing it, and I'm not judging, I'm not, I'm not involved in the situation, the tensions, everything, but from an advocacy perspective, it's a problem that why are other states going to say, if you approach them as a human rights organization, you have to refer the situation in Armenia. If they are friendly with Armenia, they'll go to see Armenia as a state and say, why are you not doing, etc. You can imagine the conundrum.
So let me ask,
it's the same with the cooperation.
But here's a conundrum that is very unique with regards to the people of Artsakh. Okay? Internationally, they have been considered territorially a part of Azerbaijan. Okay? Azerbaijan would never bring a case anywhere on behalf of, if you call them, the minority Armenians in Azerbaijan, right? They are now out of their land. They are in Armenia, call it the host country, the friendly host country where they've been given refugee status. Can a group like that self-represent itself to the ICC? Because technically, if you think about it, Armenia is just the host country. Azerbaijan is the culprit. You see the dilemma for 150,000 people.
Yeah. The thing is, we can be creative if we put aside politics.
Let's be creative.
The fact that Armenia never recognized Artsakh, what I heard yesterday morning, is also a problem, because even if the people from there want to claim, you could trigger a sovereignty claim or an independence claim. I mean, obviously it's not comparable to the situation of Palestine.
Right.
But if you see how Palestine progressively obtained recognition and statehood, de facto, until it got recognized as a state party to the Rome Statute, I'm not saying you can just apply that, but there's a process, it's a state of mind. So you can trigger and use the idea of making noise. So we can explore these options further. We're not going to do this in our panel.
You have 30 seconds.
Yeah, but there are ways, but I think that, again, it does bring back to the biggest obstacle of Armenia's position vis-à-vis all those issues, because from what I understand, Armenia as a state would not support this kind of claim necessarily, because itself it did not recognize Artsakh as an independent state. So
we don't get involved in politics either, so we keep it clean. Go ahead, Joanna.
If I may add something, actually, it's worse than that. Because it's not that they're just not talking about Artsakh, even what's going on within their own borders. Can you imagine Azerbaijan demanded 4 villages and they were handed over? That's shocking at this stage. You know, they're voluntarily ceding their sovereign territory. So it's much further than you think. But at the same time, I understand that the victims do not have the choice. The situation in Artsakh was, I think, probably closer to Kosovo, no? Except now they don't even have land, they don't have effective control. So any claims in that sense would be much harder. But yeah, you don't have the choice, no. But memorandum of understandings can also be with international organizations, like, that are ad hoc or whatever. But there can be memorandums of understanding, for instance, with the International Commission of Jurists, might have, but they're international in nature, they're not domestic.
All the conversations that are happening here, for all of you who are here, these are questions that are constantly going to be posed to you. So we've invited you to help us solve these problems, so I thank you.